Hello and welcome to the true power of paper, the importance of legal documents for your Medicare customers. My name is Carol. Today I'm going to be sharing my PowerPoint presentation with you, and I'm actually going to put that on the screen so it's a little easier rather than you having to stare at my face for an hour. You can at least look at the screen and hopefully the colors and things will be bright and cheerful for you. All right. So again, thank you. Thank you for coming. It's so nice to meet all of you, and I'm so glad that you're here today. Thank you for attending WAPCON, and thank you for your attention. The first thing that I want to touch base on is some housekeeping items. Who wants to talk about housekeeping? Not me, but I have to. So the first thing I want to tell you is mute your computer or your device. The only thing that I probably, and most of us hate worse than anything, is hearing chomping chips in the background or dogs barking or, kids screaming or whatever else might be happening in the background. So mute your computer or your device. I also wanted to remind you to ask questions in the chat feature. That's where I'll be answering all of the questions today. Wanted to remind you also to remember to download the information that I've supplied in my booth. I've tried to put very helpful pieces of information, links, data, downloads, anything that I think will be helpful for you. And then finally, connect with me. Old school through a face-to-face meeting, new school through email, and even newer school through social media. Again, my name is Carol Aragon-Montgomery, and I have been in the senior industry, long-term care industry for 30 plus years at this point, almost getting ready to do 31 years, all in the same field, working in the same field for 30 years. 4 of those years I worked at a law firm, and that's where I gathered my knowledge and basic information on education and preparing proper documents when I worked there. And then for the past 20 years, I've been a self-employed small business owner. Been working in the legal world since 1998 and have been an Arizona certified legal document preparer since 2003. What an Arizona legal document preparer is allowed to do is prepare documents for people that are not represented by an attorney and aren't looking for legal advice. However, what I can do is provide education, evaluation, and options to people so that they can make informed decisions about what they want to do with regard to their legal documents. Today's agenda, the power of properly prepared paperwork. The first thing that we're going to talk about today is life care planning, the value of powers of attorney and advance directives. The second thing we'll talk about today is estate planning. I really want to chat about the value of having an estate plan in place and using that estate plan to prevent probate. And the third thing that we'll talk about today is special needs planning. Special needs planning with regard to government assistance and other reasons why you might want to consider doing special needs planning. So why prepare? I want you guys to look around at the attendees. You can probably see them either at the top of your screen or at the side of your screen. However many people are attending today, doesn't matter, because the statistic is that 1 in 2 people is going to need some sort of long-term care in their lifetime. It may not be long-term care permanently, but it is going to need some sort of long-term care services at some point. The second statistic that I want to share with you is that only 1 in 4 Arizona residents and 1 in 3 across the United States have any type of life care planning in place. Additionally, only 4 in 10 people have any type of estate planning in place, which means 25 to 60% of you are going to rely on the government's plan for your life care and estate planning. The current US population is around 333 million people. Of those 333 million, 259 million are adults. Based on the statistics that I just shared with you, that means 129 million, more than 129 million, are going to need some form of long-term care at some point in their life. It also means that 173 to 194 million people have no life care planning documents in place. And over 155 million people have no estate planning in place. Now, some of those people will have estates that will be small enough that they won't have to go through probate, but the average US inheritance is roughly $177,000. So that exceeds most small estate probate statute across the United States. And that means their estates will have to be probated in order to be distributed to their heirs. Why prepare? Well, I can tell you that there's not one person here, not one, who is guaranteed a tomorrow, who is guaranteed a life free from accidents, who's guaranteed a life free from illness, who's guaranteed a life free from terminal conditions. You guys know that better than anybody working in the Medicare world. So many people that you're dealing with have some sort of medical condition. How many medications do you have to type in every AEP to see what the medications are going to cost? It's astounding. But we're not guaranteed to have that life free from any of that. So I always say to my clients, it's never too early to plan, but it's never too late to plan either. The first thing that we're going to talk about is the power of life and end-of-life care planning. The documents that are associated with life care and end-of-life care planning include the financial power of attorney, the medical power of attorney, the mental health care power of attorney, the living will, also known as an advance directive, the post form, and the DNR form. The most important thing that I like to share with people with regard to these documents is when these documents are effective. So financial power of attorney, medical and mental health care power of attorney are all documents that allow you to name someone to act in your stead should you become incapacitated and unable to manage your own affairs. As the financial power of attorney indicates, it's for financial matters. It's going to be the document that allows somebody to buy or sell items. It's going to be the document that allows you to enroll in health insurance or life insurance or any of the policies that you might have. It allows you to manage their finances, to pay bills, to open their mail, to access their accounts. It's a very broad document that gives a lot of powers to buy, sell, encumber, and so on and so forth. This document is only effective when you choose. So while you're competent and capable to sign your own document, you can name an agent to be effective immediately the day that you sign the document, or you can delay that power until they can prove with the doctor's note or with the doctor's evaluation that you now lack the capacity to make your own financial decisions. So very important distinction there. Probably a common issue that I see when people talk about life care planning documents is they're afraid. They're afraid that if they give somebody power, that those people are going to abuse that power. So the first thing that I say to that is, well, don't name that person. If you don't trust them to make good decisions for you, they shouldn't be named on your documents. And not only that, but you want to name a primary power of attorney agent and backup power of attorney agents in case something happens to your primary agent. So again, financial power of attorney for financial matters, effective when you choose, either effective immediately or upon incapacity, and that's going to give them broad powers to make financial decisions for you. On the medical and mental health care power of attorney, those documents are only going to be effective at incapacity. And that's because up until that point in your life where you're unable to make decisions, you're going to be the one that the doctors and the providers talk to. They're going to ask your opinion for everything. Do you want surgery? Do you not want surgery? Do you want treatment? Do you not want treatment? Do you want to be admitted to a facility or not? What's going on in your medical world and what decisions that need to be made? But when you get to a point where you lack capacity to make your own decisions, then your agent can step in and make those decisions for you. Again, if you have a properly signed medical power of attorney. Now in Arizona, we deal a lot with the mental health care power of attorney. I'm starting to see this crop up in more states than Arizona, but in Arizona, as well as states like Florida, there are a lot of elderly people, and we were running into some issues where the statute said that the person could only self-admit. There was only a way for the other person to admit them if they had that power signed that said that they could admit them into a psychiatric facility. So Arizona came up with the mental health care power of attorney to allow people to name somebody to be able to step in and make those decisions. Probably my craziest story that I ever had to deal with regard to mental health care power of attorney or lack thereof was I did have an elderly client who was climbing over fences. He had Alzheimer's, a form of dementia, and he was climbing over the fences and escaping from his assisted living facility. They couldn't quite get him balanced, and so they had to admit him into a psychiatric facility. However, he didn't have a mental health care power of attorney, so he couldn't self-admit, and somebody had to become his guardian so that he could be admitted and get some long-term benefits of being in psychiatric care. So those are the bad things of having no documents, right? Now, again, with the medical and mental health care power of attorney, they're only effective at incapacity. There are a few states that do give you the authority to initial and say, no, I want those powers to be effective today. But generally, what I'm seeing across the United States is those are only effective when the doctor says you lack the capacity to make your own decisions. The next documents I want to chat about are the living will or advance directives. These are so important for our clients because we want to make sure that they are stipulating what kind of end-of-life care that they want, should they be in a terminal condition, a persistent vegetative state, or in an irreversible coma that the doctors do not believe that they're ever going to get out of. So it's really important to talk to people about these documents, because if they don't have them, we're going to talk about that next, what's going to happen. The post form and the DNR form are forms of documents that when you get to a situation in your life where you're no longer wanting any type of heroic measures. So for example, I'll use a cancer client of mine. They're just to the point where they're like, I just, if I have a heart attack today, please don't restart my heart. I'm dying from cancer. I don't want to come back and finish dying from cancer. So these are documents that you would talk to your doctor about. You would talk with your doctor to discuss what those physician orders mean, what the do not resuscitate orders mean, what that means with regard to your health care, what that means with regard to machines that you get hooked up to or not hooked up to, whether or not you get hand-fed or intubated with food and fluids. So those are all documents that a doctor is going to need to talk with you about. And again, those are only really effective at the end of your life, or at the end of the point of your life where you're deciding, I just don't want anything extra at the end of my life. Some key points for all of the financial power of attorneys is it's very, very important for you to have those documents properly signed. If you don't have them properly signed, then they're not going to be valid, right? And then what's going to happen? So most financial power of attorney documents need to be signed, witnessed, and notarized. Not all of them. Some require a witness or a notary, but especially with regard to financial power of attorneys, you need to make sure that you have the proper number of witnesses along with the notary that's signing those documents. These documents also include a HIPAA release. Most of you know what HIPAA is because you're working in the Medicare world, but for those of you that don't, HIPAA is just a policy that says that the medical providers are supposed to keep your medical information, diagnoses, and information about your medical and mental health care private. Only when you give somebody authorization can they know about the details of your medical information, okay? So most of these nowadays include that HIPAA waiver right in them so that you can use them if you need to have them, an agent power of attorney talk to maybe the health insurance agent or maybe the health insurance company. So super important for us as Medicare insurance agents to make sure that we are encouraging people to consider getting these documents done while they're competent and while they're capable of still signing. The advanced directives, the post form, and the DNR form Really, just really important that they need to be signed properly, signed, witnessed, and doctor acknowledged, and that they meet the statute for your particular state. For example, in the state of Arizona, our DNR has to be on orange 8.5 by 11 paper. So if they have their form, but it's not properly formatted on the proper color of paper, they're not going to honor your request. So super important to follow the rules. So what happens with no plan and no paper in place? You have no power. And the power really is going to come from having to pursue legal action through the courts, through guardianships and conservatorships. Guardianships are going to be really primarily for things that would be handled normally through a medical power of attorney or a mental health care power of attorney. So again, the story that I said where somebody had to go to court and get authorization from the court to admit their person into a psychiatric facility. This is a perfect example of that. Now, guardianships are done through the court. A judge is going to be the one that decides who is going to be named guardian, and anybody that you know or anybody that has your interest at heart can apply to become your guardian. However, they're always going to look to see, are those people in the normal range of people that would normally be put in that position. So children for parents, parents for children, nieces or nephews if there are no children, brothers or sisters, so on and so forth. Some random stranger is not going to necessarily be able to become appointed as your guardian unless nobody else steps up. So it's just really important that if you don't have the documents in place, that you understand there's going to be a plan. It's just going to be the government's plan. Now, when you're going through the guardianship process, there are two main things that are going to happen. One is the ward or the person who's incapacitated or you believe to be incapacitated has to have their own attorney because their rights have to be protected. And only an independent attorney can do that. You can't hire one attorney to handle both of your sides of the case. They have to have their own. So there's going to be a cost associated with that. Additionally, there's going to be the cost associated with a full medical evaluation and a mental health care evaluation to determine if the person is truly incapacitated, okay? And again, that's done through the court. And you'll have to go in periodically and update the court as to the progress of the case. The second type is a conservatorship, and conservatorships are going to be in relation to money. So you can do a guardian. If you don't have a lot of money in the case, they might just do a guardianship and not a conservatorship. But if there's more than $10,000, they're going to need to do a conservatorship. Again, that's done through the court. A judge decides who. You must have a bond if you're going to be named conservator. And from that point on, the court is involved in any financial decision-making progress. It's going to be very important for the court to make sure that somebody is managing your money properly if you don't need somebody in advance to do that for you. It's a very costly affair to go through guardianship and conservatorship because both involve the cost of attorneys, sometimes one, sometimes two. And the cost can range. The minimum I've seen is around $2,000, with the max that I've seen around $10,000, but I had an attorney tell me that he had a case that was over $30,000 in fees because everybody was fighting. So with no plan and no paper in place, you have no power. All right, on to a new topic. Guardianships and conservatorships are kind of sad, so it's like perk it up a little bit, right? All right, so the next thing that we're going to chat about is the power of estate planning. And with all types of estate planning or with any kind of planning, if you don't have a plan in place, who has that in place? The government has a plan in place. So if you have nothing in place and you don't have a plan, you didn't do any paperwork in advance, you didn't sign any paperwork, the government's plan is not going to dictate who gets to inherit what. For example, in the state of Arizona, the normal order is your spouse, if you're still married to them. Then if you don't have a spouse, if you have adult children or really any children from any marriage, those would be your next heirs. And then if any of those children have died, it would be any children that they have or your grandchildren. So that's generally the path that's taken. Now, what if you're remarried? What if you have no kids? What if you have no grandkids? it's going to be really important for you to have a plan. And if you don't, the government's going to dictate what happens. So let's say, for example, that you don't have a plan. You are married, but it's your second marriage, and you have children maybe from this marriage, and you have children from a prior marriage. What happens in the state of Arizona is half goes to your current spouse and half goes to your children, all of your children, biological. So what if you're in your second marriage, but you've been married to that person for 30, 40, 50 years, and just because it's your second marriage doesn't mean you don't want that person to inherit everything? Well, if you don't make a plan, the government says, too bad, 50% goes to the spouse and 50% goes to your children. So if you don't want that, you need to have a plan in place. If you have no kids, again, there's a plan. There's an order of things. Sometimes they look, do you have parents? Do you have siblings? Do you have nieces and nephews? So there's a whole plan that's in place for you to be able to have your estate go to somebody. And then last but not least, if you don't have anybody, nobody can be found, your estate will get escheated to the state. And if nobody claims it after a certain period of time, then the state will get to keep the money. All right, the second document with regard to estate planning is a last will and testament. Now, a last will and testament is just a document that's putting into place who is going to be your executor or who's going to be managing your estate when you die, what you have, they're going to collect all the data for the estate and say, okay, these are all the assets and all the income and any debts that are being dealt with, and then who's going to inherit and how much. So that's all this document does. It's public record if you end up having to go through probate, and many people think that a last will and testament prevents probate, and I want to be the first person, if you've never heard it before, to say it does not prevent probate. Doing a last will and testament is a beautiful document if you have unusual circumstances and the normal order of things in the government plan doesn't work for you. But what it doesn't do is prevent probate. And many, many people come to me thinking that it can prevent probate for them. So it doesn't prevent probate. However, if you have a last will and testament, you have assets less than the small estate affidavit limit for your estate, then you may be able to use that will to make sure that you get the money and distribute it to the right person. It does simplify things in terms of who's managing the estate, and then they can then distribute that to whoever it needs to be distributed to. If you don't have a will, then all of the heirs, all of the legal heirs have to sign off on the small estate affidavit. So that's where it can get a little bit complicated. And that's when you would at least want a last will and testament to stipulate who's going to manage and then how they're going to distribute it when you die. The next power of estate planning is in relation to a revocable living trust. And that is a document, it's kind of like, liken it to kind of like a corporation or a business plan. You are saying this trust, this agreement between me and my spouse, or just between me if I'm a single individual, or me and my significant other if you decide you want to co-plan together, you're creating an agreement that says, this is how I want my stuff to be managed while I'm alive. If I become incapacitated, here's the next plan of how I want it to be managed. And then thirdly, this is what I want to happen when I die. It's valid in all three of those scenarios. And if you properly fund a trust by either naming the trust as the owner or naming the trust as the beneficiary, your estate planning can be seamless, meaning that your successor trustee can just step in and help manage your estate when the time comes. You're either incapacitated or when you die. The other thing that a trust does so beautifully is it prevents probate. So it's a nice way to keep everything out of the public eye. Your successor trustee just steps in and starts managing things. When they get your death certificate, they have to prove, of course, that you died, or they have to get a letter from a doctor proving you're incapacitated. And then it also allows you to create other contingency plans. So for example, My husband and I are a his, hers, ours marriage. I have a daughter, he had a son, and we have one together. And so under the traditional planning, without having any plan in place, if I died first, my husband would get half the estate and my 2 children would get the other half. My stepson, however, would be left out because he's not my natural heir, and vice versa. If my husband died, I get half, and then his 2 biological children get the other 50%. And then my daughter would be disinherited. So we didn't want that to happen. So we did a trust so we could stipulate that all 3 children are considered equal in our eyes. We don't distinguish between step or biological. Okay, so that's a neat thing that you can do with trusts. Additionally, if you have special needs heirs, it's a great tool to be able to create sub-trusts inside of the trust to designate monies for those heirs to be managed by a third party, either your trustee or a corporation or whoever you want to manage that. And then the last thing that I really, really, really love about trust is it allows you to have a plan and a backup plan and a backup plan and another backup plan. So generally, whenever I'm meeting with families, I make them think 3 levels deep, because everybody says, oh, I just want my kids to inherit it. I'm like, okay, but what if one of your kids dies? What if they have children? What if those children are minors? Who's going to inherit it then? Do you want it to just go to your other children? Do you want it to go to the minor grandchildren? Do you want to set up sub-trusts for those children? What's going to happen? And then next level, what's going to happen if that doesn't work out, or if somebody doesn't have a child, so just trying to think through several layers, as many as I can get them to think about, because what if they become incapacitated next week? What if they're in a car accident next week? What if they have a stroke next week? Their plan may not be able to be changed. So if I make them think 3 or 4 levels deep, we've now thought of every possible contingency to make sure that they have a plan in place that's going to work. It's not going to get messed up because they became incapacitated. And then finally, there are alternate methods of estate planning. And this is just as powerful as doing wills and trusts. So often people come to me with wills and trusts, but it's really important to know that those are not the only ways that you can prevent probate. Wills and trusts are nice when you have wonky craziness in your family, right? Children from multiple marriages, you have special needs people, maybe you have a lot of chaos in your life, a lot of different kinds of assets. You don't have simple. Those are great for that kind of setting. But if you have a simple estate, maybe it's just you and you have 1 adult child and 1 adult grandchild, and there's, that's really it. You're 3 levels deep already. That's all you really need to think about. Well, other kinds or alternative forms of estate planning can work. So for example, they are typically simple and less costly. You can use a beneficiary deed or a transfer on death deed that will allow you to designate somebody to inherit your real property should you pass away, and it prevents probate. It's a beautiful tool. I love that tool for simple estates. Now, if you have 7 children, leaving the beneficiary deed to all 7 children is going to make a little bit of a mess when they get ready to sell that property. Or what if somebody's living in that property? That's going to be a little bit more complex, and you might want to think about a revocable living trust in that situation. But beneficiary deeds are beautiful. They're simple, less costly, and it's easy. It's one and done, get it done. The second thing, at least for Arizona residents, is a MVD beneficiary form. So in Arizona, they do allow us to do a beneficiary form, attach it to our title to our cars, and then that person can inherit that property or that vehicle, snowmobile, whatever you have at the time of your death. Oh, I did want to go back on the beneficiary deeds. In other states, they refer to them as transfer on death deeds. So it's just real important to remember that's the same thing that I'm talking about there for those people that are from other states that aren't from Arizona. The next one that's really, really easy to do is the POD, or the paid on death, on financial accounts. So many people do not know this exists. Many bankers do not talk to you about this when you go in and set up your bank accounts. I mean, I had my bank account at a credit union for over 30 years. Hard to believe that, but I have. And I don't recall them asking me if I wanted to name a beneficiary when I opened that account. So it's really simple. If you have a simple estate, again, if you have a couple, for example, or two people that are on the account, if one of them dies, the last person inherits whatever's in that account. But when this person dies, the POD is going to say who gets that money. And you can name one or more. It's up to you if you want to do that. And then the last thing that I like to remind people to do is to do their beneficiary and contingent beneficiary designations on life insurance, IRAs, annuities, retirement accounts, any of those things out there that have a beneficiary designation. Make sure that you're keeping up on your beneficiary designations. So always have a primary named or multiple primaries, and then always think about what happens if my primary people are deceased or aren't around, or I don't have a relationship with them anymore. Who else do I want to inherit that money? So if they're on there, they're always going to inherit it. If you don't want them to be on there anymore, you need to go in and fix that. Super important to keep those documents updated. So here's where I want to talk about the value of a revocable living trust versus the value of the alternate methods. So the alternate methods are simple and less costly, but they do require upkeep. As long as you're competent and capable, you need to go in periodically and make sure that those beneficiary deeds, MDD beneficiary form, PODs, and beneficiary designations are all accurate and up to date. Failure to do that means that your estate plan could get messed up when you die. The difference between that and a revocable living trust is that hopefully you've thought through several levels so that if something happens, though all that plan is already in place, as long as you've named the asset as the trust as a beneficiary of your asset, or you've titled your asset to the name of your trust, the trust is going to manage that, and whatever stipulations you had inside of that trust are going to be there even upon your incapacity. It's a beautiful tool, and your trustees do have the right to add extra things to your trust later on. So with regular, alternate methods, they don't really have the authority to make changes unless you specifically designated that in your power of attorney document. Anyway, I digress. I always get excited about estate planning. People think I'm a little weird because of that, but there's just so much. And I just want you guys to know, because the more you know, the more you can share. And if we can help with that, if you feel like we're a valuable resource to your clients, we would love a referral from you. Let them know that people like me exist. They don't have to just come to me. They can go to attorneys, they can go to other document preparers, but I can help them if you want me to help your clients. All right, let's go into special treatment trusts, or I guess the power of special needs planning. There are three main things that I want to talk about here. One is special treatment trusts, which are specifically used to qualify for Medicaid and long-term care programs. There are Medicaid planning trusts, which give you the ability to save your money or give it away early so that you don't have to spend that down. And then the third trust is a special needs trust, which is to protect heirs from themselves, creditors, or government assistance spend down. Okay. So the first topic is the special treatment trust. Again, those are for Medicaid long-term care programs, and there are three types of special treatment trusts. The first type is the income only, also known as an income cap trust, also known as a Miller trust. Has lots of different names. Just in case you don't get bogged down with one, you have another one you have to learn. But there are three types, and the income only trust is specifically designed for people who are over the income limit for Medicaid long-term care programs. As I mentioned before, 1 in 2 people is going to need long-term care at some point in their life. And if they do need it and they're over the income limit, which right now is roughly around $2,300 a month, they might need to use an income only trust to income qualify for those special benefits under Medicaid long-term care. This trust is only for income. It's not for assets. I get a lot of calls every day for people that ask me, is this a trust that I can save assets or hide assets from Medicaid? And the answer to that is absolutely not. That is not something that you can hide. It's income only, only for that purpose. and the state is the beneficiary of those funds when that person dies. The second trust is a disabled under 65 trust. And this is going to be for individuals who maybe are already on the Medicaid program and now come into some sort of money. Some examples of things that I've seen: people who are in car accidents and get a settlement, people who divorce and have funds that come in from the divorce settlement, people that inherit money from heirs, from family members that didn't do any special needs planning. So these are individuals that are on Medicaid. They're under 65, they're disabled, they could be any age from 18 to 64, and they all of a sudden have a bunch of money. The asset limit for Medicaid long-term care is only $2,000 for a single individual. So now if they inherit a bunch of money or come into a bunch of money, they can get discontinued from the program. This disabled under 65 trust allows them to be able to keep those assets, put them into this special trust, which the government program will exclude, and still allow them to access those funds to pay for things that they need. I had an individual that let me do this for them one time. They came to me, we prepared this trust for them, and she's a young person. She's only in her 30s. She got a divorce settlement, and we had all this money, and we wanted to keep her on the program because her cost of care was just so expensive if she came off the program. So now we've set up this special needs trust, or a special treatment trust for her, that allows her trustee to go in and pull monies out to supplement, not supplant, her Medicare, Medicaid benefits. Whew, sorry, too many words going on here. All right, so it's a really cool tool that can be used to keep people Medicaid long-term care qualified. And then the third trust is the pooled trust. And that is one that is really managed through a nonprofit organization where they pool the money all together with other special needs beneficiaries. That is not something that we do. It exists. If people want to do that and they want a nonprofit to pool the money with other people, you absolutely can check into that. That you would need to do with the nonprofit organization though. And then as a reminder, at death, whatever money is left in any one of these three trusts, Medicaid is the beneficiary, not their heirs. So it's really important for people to understand the pros and cons of this, because I have had a few people who are like, ooh, I don't like that. Is there anything else we can do for planning instead? Again, we're not talking about that today. That's a whole other hour conversation, but just know that there are other ways to plan as well. All right. Medicaid planning trusts are going to be irrevocable trusts where you create a trust that can be for your benefit or can be for the benefit of another person, but you make the money inaccessible to yourself. So for example, I had a client who created a trust for their parents. All the parents transferred all the money to their son. The son created a irrevocable Medicaid planning trust that was for the benefit of his parents, but that he himself had control over, and that Medicaid couldn't force him to access those funds. Well, in order to do that, we had to plan years in advance because they wanted to transfer a lot of money and they made it inaccessible to themselves. Medicaid is going to look back 5 years to see if you gave away any money or vehicles or property. And if you did, they're going to penalize you. But if you plan far enough in advance, at least 5 years, on the 5th year and 1 day, you can apply for Medicaid, and then that trust won't affect your eligibility anymore. The only way it can affect your eligibility is if you disperse money back directly to the beneficiary. Okay, so just keep that in mind. So irrevocable, planning 5 years in advance, making the money inaccessible. It saves your assets from spend down and allows you to pass more funds to your heirs rather than having to spend them down for any kind of Medicaid program. The last special needs planning trust that I want to talk to you about is the special needs trust. And these trusts are for the benefit of a beneficiary who's either underage, and underage can mean a lot of things. It can be somebody who's under the age of 18, a minor, or it could be that inside of your revocable trust, you said, I don't really want my kids to inherit money if they're 18, 19, 20, 21, 22, you know, whatever age that you don't want them to have the money directly. So special needs Special needs trust can be set up for somebody maybe under the age of 25 so that they don't have access to all those funds at that time. It can also be for somebody who's incapacitated. It can be for somebody who suffers from substance abuse, or maybe they have difficulty managing their funds, or they're a vulnerable adult, or they have creditor claims and you don't want the creditors to take the inheritance, or maybe they're divorcing and they're in an ugly divorce situation where the spouse might want to try to access those funds in some way. A special needs trust allows you to either create a separate standalone special needs trust or one within your current trust document that says, if anybody meets any of this criteria, I authorize the trustee to create this trust to and for the benefit of this particular heir. And it protects them because if they inherited inside of a special needs trust and they're on any type of government assistance now or will be in the future, they're not required to spend those funds down because it's not technically their money unless the trustee decides they want to distribute it to and for their benefit. Okay, so very cool way to do some planning with regard to special needs individuals. All right, the last thing that I want to chat about is really the power of paper organization. It's not enough for you to get the paper done. It's not enough for you to sign them, for them to be properly prepared and signed. It's not enough. You need to go one level deeper, and that is organizing your paperwork. You need to be consistent with your filing. Don't put your bank statements in your dresser drawer and your life insurance policies in the safe and your power of attorney documents underneath your desk, and don't have 17 different places. Have one place, be consistent, file, and put things away so people can find them. A place for everything and everything in its place. Keep clean, organized records. Do not commingle your money with somebody else. Keep everything clean and clear, because you don't know if you're going to need some sort of government assistance in the future, and they're going to ask you about all the craziness that's going on in your accounts. So keep everything clean and organized. And finally, tell somebody where to find your stuff. Don't put them in a safe place and not have your power of attorney agent know where they are, or not tell your children or your spouse or whomever what's going on. So for example, in my life, I'm the paper goddess, right? I'm the paper god. If my husband wants a piece of paper or wants to know where a document is filed or wants to have the digital version of the document, he doesn't go on his own. He comes to see me. But if I'm not there, we've had a discussion as to how I'm planning. I have one place where he can go look everything up. So if I predecease him, it's not a surprise. He knows everything where it's at. I filed everything. I have one folder that I keep everything in, so it's easy for him. And I keep a spreadsheet of every asset that we own, how much its value is. I go in quarterly and I put the updated balances in for him. I have all of our bills on a sheet, all of the dates, how it's paid. I have all of that set up for him, because if I die first, he's going to be flailing unless I leave him with a prepared plan, right? Where is the paperwork and how do I access it? Okay, super, super important. All right, we've come to the magic crystal ball, and I want you to think, can you foretell the future? Do you know if you're going to need long-term care? Do you know if you're going to be in an accident? Do you know if you're going to have an illness? Do you know if you're going to be incapacitated? How many of us know? How many of us have a crystal ball that's going to tell us everything that we need to know for our future? We don't. Nobody has a crystal ball. Well, maybe some psychics do, but generally speaking, nobody has a crystal ball. Nobody knows what's going to happen in their future. So you need to have properly prepared paper so it can help you have a plan in place in case that does happen in your particular scenario. The true power of properly prepared paperwork. I want you to pass on your properly prepared paperwork and your plans to your power of attorney. I want you to parcel out your end-of-life perspective and point of view. I want you to promote positive personal dialogue so people can improve your position. You can do it. I believe in you. And you take that power and you pass it on to your clients so they have that information too. Thank you. Thank you for coming today. I hope you understand the true power of paper. Remember, download the information from my booth. Connect with me, again, old school, face-to-face, new school, email, or even newer school on social media. I'll now open it up for questions. And if you don't have any questions, I hope you have a wonderful rest of WAPCON, a wonderful rest of your life, and take care. Thank you, guys.